Here's a contract law story that starts with a roofing crew, a driveway, and an awkward surprise. It's 1953 in Webster Parish, Louisiana. Mr. Green signs a written offer on June 10th to have Ever-Tite re-roof his house. The form says the deal becomes binding either when an authorized Ever-Tite officer signs it or when the company starts work. That last bit matters a lot. Ever-Tite plans to accept by performance. That means don't send a flowery acceptance letter, just get moving. Approvals, reports, paperwork, loading trucks with shingles and gear, assembling the crew, rolling out to Green's home. They turn up, and someone else is already on the roof. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Green had hired another contractor 2 days earlier. The on-site crew tells Ever-Tite they're out. Green won't need them anymore. That's the spark for Ever-Tite Roofing Corp. versus Green. The courts question, when did acceptance happen, and was Green's switch a breach? Commencing work, what counts? Swinging hammers, loading trucks, paying workers, transporting materials to the job. The Court of Appeal, Ever-Tite accepted when they began performance, specifically loaded the trucks and transported materials and transported workers toward the job. That's not mere preparation. That's the start the contract contemplated. Why it matters. Once acceptance happens, the contract is binding. Any attempt to revoke the offer after that is too late. Green's decision to hire someone else wasn't communicated to Ever-Tite until the crew showed up. By then, acceptance had already occurred through performance. There's another layer, reasonable time. Offers don't stay open forever. Ever-Tite moved with due diligence, handled approvals, then hit the road the day after everything cleared. The court said that timing was reasonable under the circumstances. Result? Ever-Tite won. The court awarded $311 in damages, plus 5% annual interest. Not a windfall, just the costs tied to the breach. And it established a memorable principle. Acceptance by performance can begin before anyone steps onto the roof. Loading the trucks and heading to the site counted. Takeaway. 1. If an offer allows acceptance by performance, starting the job, including logistics, can lock the contract. Takeaway 2. Revocation must arrive before acceptance. Hiring someone else without telling the original contractor doesn't cancel it if acceptance already occurred. Takeaway. 3. Reasonable time is contextual. Approvals and mobilization can be reasonable diligence. Ever-Tite versus Green turns a driveway standoff into a clean rule. Wheels rolling can be as binding as pens signing. That's a lot of law from a few shingles. Thank you for watching. If you enjoy this story, please follow along for more. See you on the next one.